We're live. Hi, good afternoon. No, still good morning. It is February 3rd. We're in Senate Judiciary. We have Susanna Davis with us to talk about S208, and the floor is all yours.
Great, thank you. For the record, Susanna Davis, Office of Racial Equity. I am here to express the office's support for S208. We see this as an important act to ensure transparency in government. The state has taken a lot of effort over the years to promote transparent governance, and I think this is a key way to do so. We know that law enforcement officers are agents of government, municipal, county, state, and federal, and as such should be bound by the higher standard that we set for those who are agents of government to be able to interact with the public. And obviously, nationally, we are experiencing what I am going to refer to as a crisis, through which our institutions, particularly some federal government agencies, have behaved in ways that make people question their intent and their commitment to that transparency. So we see S208 as an important measure that helps give people recourse in the event that their civil liberties or other dignities are being not honored, and recognizing, of course, that there are certain circumstances that would require certain exemptions. We would be in support of those reasonable exceptions being included. I also would add here that it's often the case that exceptions to rules like these can be abused. And so being able to have recourse for how they're to be applied, what happens when they're abused or misused. I'm thinking, for example, in my time in New York, where we had similar municipal level legislation that passed, and there were certain members of the NYPD who made it their business to try to get around it. Taping badges, switching cards, switching badges, things like that, so that you could technically say I was identified, but in practice weren't. So not that I am implying that that would be happening in Vermont, but I do think that it would be important for any policy of this nature to be articulated really clearly, and for us to have a process for how it's reviewed, whether it's through things like review of footage, review of civilian complaints, or other methods for determining whether the policy was violated, and if so, what would be done about it. The office also lends itself at the service of the Criminal Justice Council if we can give its advice in any way in developing the model policy that they're called upon to create in this bill. And otherwise, we see this as a really important measure to protect people, particularly those who tend to bear the brunt of this illness in the state. Of course, people of color, but also people living with disabilities, people who may be immigrants in this country, and people who are low income, which includes a large swath of this state.
Thank you. Any Thank you very much.
Thank you.
Right. Time.
Julio's right outside, I think.
Okay.
I'm happy to sit in the chair, but I think he's a better. And apologies to me, how we right.
Yeah, related. Okay. Will the both of you take more? Are you going to need more than 15 minutes? Okay. Thank you.
Sounds good. Let's go forward with the testimony. So, good morning. For the record, I'm Hal Dalos, Assistant Attorney General for Vermont Attorney General's Office. My colleague Julio Thompson will be providing a little more depth on our views on S208. The first thing I would start with is that in July of this year, we signed on to a multi-state letter with a number of other attorneys general advocating for federal legislation in this space, really believing that federal legislation would be the right answer to ensure the safety of individuals throughout the country. And so we have pushed in that direction. I think it's pretty clear to this committee that a federal solution is not forthcoming. In fact, it would appear that the federal government is the main problem. I would also say, as on a policy level, we support broadly the way that law enforcement operates generally in the state, and have real concerns over how law enforcement in the federal space is operating in the manner that is undercutting a lot of responsibility community to live with our law enforcement laws, and recognize the real toll that is taken. Certainly in other places around the country, and have real concerns about what toll it might take the law if we see similar actions here. Beyond that, I would say that S208 steps into a space that is an open area of law. It is not a settled area of law. And our main position on this, and again, I'll defer to Julio for more information on this one, is with a case largely on point in California. We believe it's important to see how that case plays out before stepping further into this area at this time. So with the open questions around the law, that's our position.
This might be a question for Julio, but my understanding, and I want to make sure that that's your understanding as well, is that the case in California is being litigated explicitly on the grounds that it is discriminatory because it only applies to the federal government. And so as I see it, this is completely different in that it is not, and it does not only apply to the federal government.
I would agree with the latter half of this bill is broader than the California law. The grounds on which the federal government sought to enjoin or stop the California law, part of it is discrimination based on the fact that it didn't apply to California police officers. But there are other claims around preemption and the supremacy clause as well, and that would seem to be germane to the way this bill is.
Senator, I would just note that in the discussions around the government shutdown, there is the prospect, perhaps, of an agreement that would speed to some of this. I share the general lack of confidence that that ultimate agreement will do the right thing, but at least the news reports are indicating that Democrats in the Senate hope to add those protections into what would be the DHS funding bill. But I believe this is utterly necessary because at this point, my level of confidence in the federal government restraining itself is very
I agree with Senator Burke, and I also just wanted to make you aware, if you weren't, that this has come up as an issue with our local, with some in local police instances as well.
Yeah, I guess I'd be more interested in, you said some of this would be germane to what this law has to, such as the federal supremacy clause, you mentioned something else. What issues are we looking at?
So that, if you're ready, I'll let Julio speak more to the details there. Well, I wouldn't dismiss them as details. I think the central elements of where the law is open and what the questions in California are that we think may be valuable for understanding before the law takes a step. So if I may see, thank you. Thank you.
Good morning, and then apologies for writing something late. For the record, Julio Thompson, Attorney General's Office, Civil Rights Unit. And I won't repeat too much points that my colleague here has outlined for the committee, but I will add a couple of pieces that I think were not addressed, and maybe I can add clarified pieces maybe that were at least mentioned. In the California case,
federal government is indeed making two arguments for unconstitutionality against the two California laws. The first argument in their briefs is that it directly regulates the government, and it's saying you can't do that. And then the second argument is that it discriminates the government because it exempts state police officers from the requirements. So both arguments have been fully briefed, and in fact, discrimination was the state's or the government's, U.S. government's fallback argument. I think press coverage of the hearing, which happened on January 14th, did, I think, accurately point out that during oral argument, Judge Schneider was focusing a lot on testing California on the issue of discrimination because there's a clear exemption for state police officers. And so that may be the source of folks. I've also heard from other other people, even in local law enforcement, who are loosely following the litigation, and they think that's the only issue. And it is not. There are cases, I mean, part of the reason that it's a tough space, that there are cases where a law that applies to everyone in a state have been held to be, where it also regulates federal authorities, have been found to be unconstitutional. A case, for example, in the state of Virginia, at least over 15 years ago, where Virginia's state licensing board for law enforcement had sought to enforce law or had a rule that all private investigators operating in the state of Virginia, all of them, would have to be licensed according to their regulatory standards. And at the time, the FBI in nearby Washington, D.C., had hired about 150 private investigators in Virginia to do background checks to act as private investigators. Then they had certain standards that the FBI found the minimum standards for their investigators, and Virginia got wind of this and notified some of the individual investigators that they were going to be subject to enforcement action because they weren't licensed. And so the FBI took the state of Virginia to court and prevailed on the notion that the state of Virginia could not substitute its judgment about what employee conduct or qualifications are over the FBI's. So that was a case involved, and didn't go to the U.S. Supreme Court, went to the Fourth Circuit Court of Appeals, which affirmed judgment for the FBI. So that's the case that lies in the other substance, where it's a rule of equal application, but it does govern the conduct of federal employees as well as people who are in the state of Virginia. So I think the issues are broader than discrimination. I think it's important for the bill that has progressed thus far that it is non-discriminatory, because I think that is just a vulnerability that I think, as the bill was introduced, is already addressed. Some of the other issues that are to be resolved, or at least we hope resolved in the California litigation, aren't necessarily the arguments about supremacy clause, the legal analysis. But because right now what's pending in front of the judge is a motion for preliminary injunction, the judge necessarily has to take into account evidence that's been submitted by both sides. And in support of its motion for the preliminary injunction, DHS has offered evidence, largely in the form of affidavits, about what it claims is, I think, an 8,000% increase in criminal threats and a 1,300% increase in assaults on ICE officers, which it claims correlates to the need to have officers at their own discretion for their own safety decisions to be masked. It's not clear what the judge is going to make of that. Last September in the District Court of Massachusetts, in a very different case involving university professors suing the Secretary of State for First Amendment violations, did address, among other things, masked federal agents who were arresting students on campus. And there was some evidence, less different evidence, but some evidence that DHS put in there about the safety risks to ICE and CBP officers as a justification for masking, or let the officers have the discretion to mask. And in that case, the district court would have none of it, didn't find the evidence credible at all. There's different evidence that's being provided in the Central District, and that's something that we would want to see, because when you're evaluating, or when the committee is considering, the legislature is considering exceptions or, what the standard will be. It will be important to know whether a court, at least one federal court, has credited some, none, or all of the testimony about threats to officers, and if that, so that may affect the language that you may want to use in the law, or the bill. Turning to the language just briefly, there are some things in there I think puts headwinds, or I should say, avoids headwinds. For example, unlike the California law, there's no criminal sanction. There's a whole different area of case law that's very unfavorable to states when they impose criminal penalties for federal officers who are not otherwise violating federal law. And so I think that, that the bill, again, I think thus far, from what we've seen of it, has avoided another pitfall.
So Julio, just to respond to that, there was a new draft that we haven't officially been presented with, which does create a sort of structure for the offenses. First offense being a ticket, the second offense being another ticket with an increased fine, the third offense being, I think, with $1,000 misdemeanor. Okay. So, yes, thoughts on that, the new information?
Again, I think we have to see the language, and I think, again, the outcome of that makes the California case all the more important to follow, because that's also a misdemeanor offense. Because there can be cases where officers are masked and engaging in unlawful acts, which, might be viewed as part of one of the same offense. For example, there is a federal civil rights statute, section 1985, that makes it a crime to conspire to wear a disguise in order to deprive people of civil rights. And it really was related to dates back to the days where federal law was addressing the Ku Klux Klan, as you can imagine.
Senator Norris and then Senator Ruth had a question.
You touched on, you got mine.
Okay. Just for your.
In terms of other languages, other comments that I think we can offer now, it's to be helpful to the committee. And I think, and we keep getting additional information that just keeps coming in, and sometimes daily. We received something today from the state of Maryland, for example. I didn't put that about the Maryland bill from their attorney general's office. But I think there was written testimony or a statement that was provided last week by an attorney, a private civil rights attorney, that pointed out, or he perceived, and I think I share the perception that the exception for undercover operations seemed to be limited only to drug undercover operations. And I did just point out to the committee, I think it's already pointed out by other witnesses, that there are other, very legitimate undercover operations that don't involve narcotics, firearms, and human trafficking is one of them. Our office, our internet crimes against children task force, our sworn officers use concealment in order to track and make safe arrests of people who are either trafficking children for children's sexual abuse materials or are selling it and disseminating.
Is it concealment by way of masking the face, or is it concealment by impersonating an underage child on bronze?
It can be both in terms of making the arrest, because some and it's a long dark person up here. We have a very talented head of that task force in our office, Matt Ranke, probably not before. But some of the concealment, some concealment is done just by text and impersonation, but there are also interactions online, obviously, to the prevalence of video, where people masquerading, pretending undercover to be interested in buying that, where it's a person. They may be speaking to an informant. And then when there's an arrest, our task force is not large, to have the ability to mask and be able to conceal the identity by covering it, as opposed to like a beard or whiskers, that kind of thing. So it's really both. They use both forms of concealment, and that's true for.
You're saying when they ultimately make the arrest, they mask up?
They can do that again.
But if we were to pass this, they wouldn't be able to
because it's not drug related, at least in the current iteration.
Right. So I'm trying to find out, are you suggesting that we include them in the carve out?
Yes, I think that, and I think other operations, you may want to hear from the law enforcement personnel who can tell you their operations better than I can. I'm a civil rights lawyer and I don't involve myself in ICAC enforcement or firearms interdiction.
I'm
But
just wondering why, if you're arresting someone who's been targeting minors online or committing an online crime, why you would need to mask up to arrest them. That doesn't necessarily make sense to me, because
well, I can tell you that all detective work is not done at the keyboard, that people meet human beings on the street, they meet informants on the street.
yeah,
And those people may be operating under an assumed identity. You could take that, the same would be true for firearms smuggling or for human trafficking. So I think, you know, and again, if you want to hear other, people who specialize in this talk about their operations, well, my understanding is it's not 100% invisible behind the keyboard.
well, I guess what I'm thinking is, if someone is an undercover cop and they work without a mask, obviously, just pretending to be somebody in the community, it would seem strange to send them to arrest people when you have other officers that could send and preserve the undercover identity of that. You know, why would you burn an undercover cop by sending them to arrest one person? So I'm probably a good idea that we talk to someone who's in charge of these operations, but I can't think of a category of law enforcement where we would want to say, yes, we're going to carve you out and in effect create different ways that people can wear masks legally. When I can't see the reason in an internet crimes case why we would not send officers with identifying information. But anyway,
Well, I think we agree on a path to find that out,
Yeah.
which is to have somebody who's more competent
yes,
than I am. But I do point out that undercover operations are broader than drugs.
So I do want us to wrap up here shortly because we're already past noon and
Okay.
Todd doesn't have his hand raised anymore. And I'd be happy to revisit this in the future. We just had a long morning, want to make sure we can grab some lunch here, but Senator Volkswagen is the last question and then okay. Do you have any closing thoughts? So we'd also be happy to have you come back if there was more. Sorry, it's such a short time frame for this.
It's okay. I understand it is quite a busy morning for everyone. I guess there are 2 points that I would raise that I don't know that they have been raised. One is that I think I applaud the committee for having asked a constitutional law professor from Columbia University that's sound in on that. We listen, I listened to that and others in our office listened to that testimony with great interest. It did not come up in the testimony that there are equally credentialed constitutional law professors who have diverging or even competing viewpoints about those issues. And I think it's important to have access to those materials. I'm aware of at least 2 pieces that have been written on the subject by different constitutional law professors. They're reading the same cases and offering a different interpretation. I think it's good to have those materials available for legislative council to look at and see whether their insights may affect, again, maybe careful language choices that are made down the road. And the final point, and this could be something that Todd already addressed, it is an important point. And so the reason that we are looking at this so carefully and so deliberately is that a poorly crafted law, we've had very recent experience on this, or one that is not as well crafted as it could be, can generate court decisions, especially Supreme Court decisions, which make the world much worse off than before the law was enacted or the lawsuit was filed. The U.S. v. Trump, the presidential immunity decision immediately springs to mind, where we ended up with a presidential immunity doctrine that was far broader than the party had ever contemplated when they brought the question to the court. There were other examples we could cite as well. That is an important, because there's likely going to be a legal challenge. And so we want to make sure that every hatch has been battened down, so to speak, and that's why we're taking such a careful look at it. And I appreciate that the committee's been doing the same, and I appreciate that you've been asking for us. But
Senator Norris has a question and then we'll wrap up.
Yeah, I just wondered if you could provide those names or whatever else maybe we could reach out to them.
Sure. And I could also, I have the articles that are available. One is a University of California Davis professor, Vikram Amar. And the other is, I think, a University of Iowa Law School, Professor Noah Chauvin.
If we just send those to our committee assistant.
We should be able to do that
That'd be great.
as well. And then I think I'm aware of a third I'm not sure if it's an academic article, but it's a well-sourced footnoted article that says it's really unclear, and it cites those sources, those competing sources as well. And all the articles offer different ideas about addressing similar issues, which is intimidation, safety, as well as accountability. And so we just think it'd be useful to have all those materials available for all of it.
So thank you.
Okay.
So,